Ahmed, the Chief Justice, Dumbuchena, former Chief Justice of Zimbabwe and Acting Judge of Appeal, and Leon, Acting Judge of Appeal. A case was cited for me here, Something Shiweather versus the state in the High Court. As I recall, the hierarchy of our courts is as follows: Supreme Court, High Court, Maj Court, Community Court. I cited Schultz because it was from the Supreme Court. And I cited a bench as heavy as 2 Chief Justices, and you cite me the High Court with the greatest respect of a single judge, single bench. The weight, if we were doing that, it's overtaken. And find me that case that says Schultz has been set aside. Now, I did refer you, Judge, to what Shabalala said about what the police docket is. At paragraph 10 of Shabalala. No, let me just do that, yeah. The police docket consists of Section A, witness statements, expert reports, documentary exhibits. Section B, internal report and memoranda. Section C, the investigation diary. That is the police docket. Schultz determined the disclosure of the police docket. If there is a judgment and it assumes to interpret Schultz otherwise, it is wrong and it cannot be followed. That is what, by the way, Digashu says. A patently wrong judgment must not be followed. Schultz remains valid, intact, extant, has not been set aside. In fact, I want to refer you to a case. Let's go into Schultz. Schultz is the one that talks about Shabalala. I don't know if you have the judgment, Judge. I have the judgment. And on page 4, the court refers to S versus Nassar, 1994, Namibia Reports 23, High Court, where it says that disclosure of the police docket is an Article 12(1)A issue, even if the state does not intend to use documents from that police docket. It was confirmed by the Supreme Court in Schultz. Then it was reported that I gave judgments here from Japan, England, Canada. As a matter of fact, I didn't give Japan, but nice try, Mr. Marondetse. I gave judgments that come from where? In Schultz, at page 9, the court deals with R.V. Stein, the 1959 case in the appellate division. Then, on page 12, the court deals with Shabalala. And there's a reason why. I explained to you. Mohammed sits here as Chief Justice. He sits there as the President of the Constitutional Court. At the time, they didn't call it Chief Justice. In 94, he makes a judgment which he writes there. He comes and applies it here, even though he doesn't write it. He wouldn't come and sit in direct opposition with his own judgment, which is being cited in the judgment he's sitting in. It's just illogical. It's unbusinesslike. And then on page 14 of that judgment, it's the same judgment, the court then refers to R.V. Stinchcombe from Canada. And then the court continues to analyze the cases. At page 21, it refers to R.V. Lesson in the UK. At page 22, R.V. Marv. At page 23, R.V. Ward. At page 26, R.V. Ward. At page 27, R.V. Ward. At page 29, R.V. Ward. Must I continue? The point I'm making is this. The court has incorporated that jurisprudence into our jurisprudence. That is the point. And I think that puts to bed that no judge. You see, there's a confusion that people have. People believe that verbal discharge an argument maketh. No, you must actually make an argument. Now, apparently there's a distinction between the investigation diary and police docket. I couldn't care the north end of a cow facing south. The issue is it's part of the police docket. That is what we want. Klar. Now, Section 30 was relied upon by the state in the case of the mutual legal assistance that was obtained. It was obtained but without a bilateral reciprocal agreement. Let me just put that discussion to bed quickly. The whole purpose of legislation being legislated is to regulate a given matter. And you can only go around it to the extent that you are permitted. That comes in now from the moment it is brought into ex nunc, ex tunc. Now, what Section 30 says is, nothing in this act contained shall be construed so as to prevent or abrogate or derogate from any arrangement or practice for the provision of obtaining international cooperation in criminal matters otherwise than in the manner provided in this act. What it means is that when this comes into law, if you were doing something, it shall not be detracted from, shall not be prevented, it shall not be derogated from. But you can't, after the coming into the act and say, listen, I don't need to think about the act. I'm going to do my own things. And then say, no. I can only give you this, I can't give you that because the act says so. If you're going to cite the act, cite the whole act. Rely on the whole act. Don't rely on what you want. That is why I read endumeni. It must be considered in a context of the entirety of the document for the purpose intended. What was that purpose? To regulate international cooperation between countries. Certainly, Judge, this is an issue that requires interpretation. It may be that I'm required to reserve this as a question of law. And the impact would be that any evidence thus obtained should not be allowed in this case. At this point, and I thought Mr. Marondeza would introduce this, there's a distinction between challenging the admissibility of evidence and dealing with the legality of evidence obtained. I want to deal with the legality of the evidence obtained. I do not want to wait for each piece of paper being brought for me to challenge its admissibility. And the rules of court to which this court has subscribed itself to because they were made for this court is to minimize the length of trials. If we can dispose of that matter, I may perhaps not need to go even into those charges that relate to information obtained without a bilateral agreement. You see, Judge, there's the case of S versus Tiek. If there's any case that shows Namibia and shows the judiciary how it has allowed itself to abuse the rights of people, it's the case of Tiek. May his soul rest in peace. He was done bad by this country, by the judiciary. In that case, paragraph 82, It had to take South African judges to come and tell you, here in Namibia, what you're doing is wrong. The respondent submitted that the irregularities committed during the investigative process violated his right to a fair trial and vitiated the proceedings. Demonstrate how the substandard investigative process by the police may be destructive to the criminal justice system. Paragraph 83 still, the evidence of the searches exculpated the respondent. It was deliberately withheld from the trial court and the defense, despite the video recording examining that exculpatory evidence. And then in paragraph 89, neither, and I'm going to read it as if I'm reading it in this case, neither the Namibian Constitution nor the Anti-Corruption Act empowered the anti-corruption to investigate any crime against any person in a selective manner for the purpose of securing a conviction of an accused person. Any person accused of having committed an offense, whether the person is a judge or is holding a position of high office, shall not be treated differently because of his or her public status. Let's not make laws and judgments for Sakeus Shanghala. Tomorrow it will be you. Let's not make laws and judgments for Sakeus Shanghala. I raise issues, you go and amend the legislation, Section 83. I raise issues, you remove the burglar bars. Mr. Marondeza says only those three are complaining. Now, had I not raised the burglar bars, which was my dignity being impaired in a judicial proceeding against what Article 8(2)(a provides in the Constitution, my co-accused's rights would also be violated. Must I keep quiet? I don't care if I'm the only one raising the law and the Constitution. I will assail and raise my rights so that they can be protected as they're entitled to be protected. I will not be rushed into a trial of illegalities. I will not. Now, Article 18(2) of the Convention Article 18(2), which Mr. Marondeza raises, it says, mutual legal assistance shall be afforded to the fullest extent possible. And then it starts now putting commas there. Relevant laws, comma, treaties, comma, agreements, and arrangements. Now, what Section 30 there in the International Cooperation Act speaks of is arrangements. But first, you must pass the relevant law. This act itself. It says there must be an agreement under 27, which the minister is empowered by the president under 32, only when it's ratified. And we can see, I've shown you how in Angola they did it properly. All that they didn't do in Angola is give us the other request done and the information received. And then they receive information, which, by the way, I want to show you that I've shown you in the replying affidavit. They receive the information. I do so on page 11 of the replying affidavit, paragraph 43.3. 1,931 pages. They only went to request it and receive it a year, 4 months, 2 weeks after my arrest. The point I'm trying to make is arrest the person on election day, do regime change if you can, then go and do the investigation. Then they only provide 149 pages translated from Portuguese to English. Why are you not giving me the other 1,700 pages? Why not? Or 700 something pages? Why must I only get, then don't give me anything because you are saying I'm not entitled to it. But why give me that and don't give me the rest? The convention judge subsidiarizes itself to national law. That is the point I've been making. He's laughing at it when I tell him that it says how many times it says according to national law, subject to national law. The point is being made ad nauseum. When we negotiate these things, we negotiate them only if national law makes international law and not the other way around. Not the other way around. Whether you look at the Convention Against Slavery, it first started with the national law. That's what Wilberforce then passed in Parliament. Then they came to the international plane. It's not the other way around. You can't sit in your office and then start claiming, and by the way, which section would you apply? The one with which standard states have an elective thing to do. And that is why there's an accountable authority. Now, before we move on from the Act, maybe we need to dispose of the issue of Section 2. Section 2 must be read again in the light of Endumeni, together with Section 6, where a letter of request is issued after proceedings have been instituted. The evidence so obtained, together with the record of the proceedings and the examination of the witness, shall be open to inspection by the parties to such proceedings. So I can't ask for it before the proceedings have actually begun. But now I can ask for it. That's why I'm asking for it now. I'm not delaying. I'm following the legislation. Was I supposed to ask of it before? And then they say, but you were the AG, you were the minister, you should have known. Now, my apologies because I have nowhere to work. And I don't know how this is going to work. By the way, there's a judgment that talks about that this place must be, I don't know how it's going to work. Anyway, let me continue. So, Section 2A must be read with Section 6. Now, I did not mean to say that the lower court must review the High Court and the Supreme Court. Let me clarify. The argument is crisp, and it is this. If you take the approach and then interpret along that approach, that Section 2 means even in court proceedings, I am not entitled to that information. What will happen is that the court cannot engage its powers under Section 18. I cannot engage my right under 18 for a review of what would have happened done by administrative bodies, or, for example, the lower court, because in the International Cooperation in Criminal Matters Act, Section 2, issue of letters of request. If at any proceedings it permits to a court or to the officer presiding at such proceedings that the examination of such proceedings in a foreign state is necessary, blah, 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 then they may issue a letter. Now, that is something being done according to law, and it should be reviewable. It happens in proceedings in the lower court. And it engages also Section 20 of the High Court Act. If documents cannot be disclosed, we will never be able to see and review and correct and set aside if irregularities had occurred in those proceedings. That is the point that is being made. Again, it just flew past, Mr. Morandeza. Then the document SES RAO, apparently the state will not rely on them. I've already referred you to the High Court case of S versus Nassar, which was approved by the Supreme Court, S versus Schultz. It puts that argument to bed. Now, the people listed, there's a list of 340 over 340 odd witnesses. Anything they say is relevant. And everything they have provided the state I want to see. It's not the state, it's the public's information. That is what the court said in S versus Schultz. Not me, S versus Schultz. Ndubuchena, Mahomet, Leon. What mightier, heavier, intellectually, jurisprudentially bench do you want to find? Apparently, I'm speculating. Let's see what S versus Schultz has to say about so-called speculations. From paragraph 25 through to 27, the court in Schultz talks about R.V. Ward, and then it concludes at the end of 27. There may be in the police docket a piece of paper referring to some event, incident, time, or other thing that will assist the accused in selecting material for his defense or reminding him, Judge, it is the way it should be done. I'm not speculating. I'm entitled to see, aha, look at that. But if it's kept away from me, how will I know that it even exists? Apparently, I want to go back to pretrial. What I want, Judge, is for us to be able to deal with all the pretrial motions, and it's not just the notice of motion, Judge, has something that we need to address. And I showed you just how difficult it was for you to find a given page out of 230 pages. What more with 165,000 pages? The point I'm making is this. The docket's not paginated. I don't have it yet. It's being photocopied. And what we know is that every time we shake the tree, some fruit falls out. Every time we shake the tree, we've done it now 4 times. Let's shake it again, more will come out. And then we can select the fruits of the poisonous tree we won't eat. The fruits that are not poisonous, we will eat. Let's not proceed with irregularities. I've already shown you how Tiek, I've shown you Hailulu, how institutions are weaponized against people, for commercial interests, by the way. I showed you the linkage. It's relevant in law, relevance. Context is everything. How it starts with Bobo Kafindi and the NAMSOF board wanting quota. Then the ACC Director General gets put under pressure by a demonstration. It's in the papers. Then he says, oh no, sure, we're going to arrest people now. Apparently he's got a memo telling him how to even draw up the charges. He's no longer acting independent and impartial, according to 94. I should be able to challenge the legality of that before we even start this nonsense case. Then we go to the state's case. It has disclosed for us. Where have you seen a case with 2 file 1s and they are all different? In the one, Bobo Kafindi is number 1. In the other one, file 1, Johannes Stefansson is number 1. Same case number. But apparently, no. They're not part of the docket. We're not going to use them. You're not entitled to them. Go and get it yourself. It's not your papers, your document. It's apparently the public's document. Not me saying it. Schultz. Relying on cases such as R.V. Ward, Stenchcombe, etc. It's Stenchcombe, yes. Now, how is it relevant, Mr. Marandeze asks? It's relevant because it gives me context. 2, it allows me to see if irregularities were conducted. 3, it allows me to see whether or not I have a defense. Or 3, whether or not it could be a misconception. 4, it allows me to see, as the Supreme Court says in Schultz, maybe there's a piece of paper that will refer me to something. It doesn't matter if the state doesn't want to use it. It doesn't matter that they haven't selected it to ask a particular witness. Do they have it in the police docket? Yes or no? If you have it, give full, not give half, give a third. I don't even know if they gave half. They gave what they gave. They give you this page, they don't give you that page. They give you this page, they don't give you that page. Why? Either give, don't give. How? Just hearing us today here, how can this be a fair trial? In which part of the universe? Maybe Earth, I'm on Earth, I need to go to Venus maybe. What is going on? And I've been a Minister of Justice defending justice in this country. This is unbelievable. I want to end off, Judge. I want to end off by showing you and demonstrating to you that this case was made out on its papers initially. If you go to the founding affidavit, there's a document numbered correspondence 27.4. It is dated 11 September 2024, addressed to Martha Olivia Ekanje Imarwa. They did receive it the same day. In paragraph 7 on page 3 of 4, I'd like to read and quote myself. Additionally, kindly avail a legible copy of the affidavit of one Mr. Silvanus Thikameni Kathindi made on 29 October 2014, end of quote. Why must you come here and ask these things? Judge, for me to come here and ask you that, it's because I have tried and I have failed. I've told you. I ask them, they don't respond to me. They keep quiet. Then Engelbrecht asks, months later, then they give Engelbrecht. Zero silence, impunity. I've asked them. And I said to you, I'm repeating it again, this case would not have been necessary had the Prosecutor General just provided us the information. This application would not have been necessary. It's a fair trial issue. And the fair trial is important because this is not me. Again, Justice Nkambinde had to come all the way from South Africa to come and sort out our mess here we did with the case of Tiek. May soul rest in peace. The importance of the fair trial right in the Constitution is to ensure adequately, among other things, that innocent people are not wrongly convicted because of the adverse effect which a wrong conviction might have on the liberty, dignity, and possibly other interests of the accused. Anything short of these constitutional imperatives may not only bring the system of criminal justice into disrepute, but may also result in a travesty of justice, as it was in that case. And as the state wants to just Deutsche Bahn here, commit travesties of justice. We need to deal with the issues here. Let's separate, sift it out. Even animals, when they go to a watering hole and want to drink, first they clear off the mud and then they drink the water. Now you just want to shove it down my throat? Illegalities that were conducted by the ACC acting on the interests of other people? The video is there. I've given you the link. Open it. You said you are on these Facebook things. I don't know what they are called. Check it. It's there. He's saying, no, very shortly we are going to arrest people. How do you say that? Namsov. They're in the placards there. Namsov, Namsov. Now we know that no jobs were lost. It was people who were not on an illegal strike. Or kapara and nonsense. Now we know. A memorandum is drafted. What is in the board meetings of Namsov, you will find in the affidavit of Bobo Kathindi. And you will find is what is being said by Kanyangela in that affidavit. I've given you everything. And it's in the summary of substantial facts. What comes from Norway is what you find in the affidavit, in the summary of some substantial fact and the indictment. And the Deloitte report. But I must not get it. How does Deloitte change from here and there? Deloitte even tells you we didn't even consult those people. But the ACC must have acted independently and impartially. That is why I need Deloitte. Why does Deloitte not talk to me? They say so. They disclaim me, say, listen, we haven't spoken to those people. I've read it for you. It's in the record. It's document age, on SES age and it's on page 2 of the letter signed by Melanie Harrison, Marius Alberts. I want to know if I can come and cross-examine this director, Marius Alberts, and this director, Marison Harrison. Marius Alberts, by the way, is based in Cape Town. He's not a compellable witness here. And I need to know so that I know why did they change, so that I know what to cross-examine or to take a point of law. I'm entitled to do that. Apparently, only just those 3. So, I want to end off, Judge, by just stating to you that, as Schultz says, I'll read it into you. That is why we are here with this application today. It says on page 6. If disclosure of statements of prosecution witnesses falls within the ambit of 12 of the Constitution, then such disclosure constitutes one of the important elements of a fair trial. Non-disclosure of relevant material. We said that they are relevant, whether they are the investigation diary, Part C, Part B, or Part A, which was discussed here. They are relevant, and the right resides in Article 12 of the Constitution. You will have noted, Judge, that they have abandoned, he didn't talk about it, this issue of you are here on the wrong section. Did he talk about it? He abandoned it. He ran away from it. It's untenable. He's shaking his head. Even him saying it's not a good point. So, on that point, Judge, unless there are any questions, we have addressed you. I'd just like to address one more issue, Judge. And I mentioned it tangentially when I was speaking. That there's an extant court order that this courtroom would be changed. Because you would see when he was talking, I'm trying to look at documents here, I'm up here. This cannot continue like this, Judge. This cage is not tenable to a fair trial. For me to just assemble them. If I had, in one day, Judge, if you would like, I can bring just the documents that we have in our possession. And then we just see how we will fit here. It cannot work. And I need to refer to them. Because today, I wanted to show you that, what Mr. Mendez was saying is not correct. There's another document in the disclosure. Because the disclosure is before us. So I couldn't do that. I don't have a document. I could have gone and checked at lunch that, in the storeroom there's that document. Indeed, and I could maybe make an argument about it. We need to deal with this issue, Judge.
Yes, I believe the matter is before Deputy Judge President Mwatelulo, and he requested a report from the 2 EDs of the Judiciary and Justice on the 5th of September, which is around the corner.
Thank you, Judge.
Yes, the case has been set down for the 8th of September. In any event, that was one of the reserved dates. 8 to 19 September. The court will then remand the case until then for my ruling in this regard. I might engage the parties between now and then to sort out some practical matters. But for now, the case then remanded until the 8th of September. For my ruling, accused 1 through to 9 remain at the Windhoek Correctional Facility. Accused number 10, bail extended on the usual conditions. Court adjourns.